5, and we are ready to resume the next phase of our meeting. So I'd like to call you back from recess and continue on. We are now ready for the exceptions hearing, so I think I'm going to pass it over to counsel and let her take it from here. I do want to say for the record that as we work through this process, we've established some timelines, counsel has, and so she will be going over those details with you. And again, we appreciate everyone for being here and in advance for the technical challenge that we will encounter. Thank you.
Chair Grail. Okay, a couple of preliminary things of note before we move into this next phase. Some of this is repetitive, but I'll just go ahead. First of all, the record is closed at this time. I just want to kind of emphasize that so you recognize you're not taking in new information. That was the purpose of the underlying contested case process and the application. And this process here that we're engaging in, where the council has an opportunity to hear from the county directly regarding the 9 exceptions that it has taken to the proposed contested case order, is something that's a matter of practice, not statute. It's something so that the council has the opportunity to hear directly, consider, and ask questions. We have worked with Chair Grail a little bit to try to figure out how to make this most productive for the council and provide a really good opportunity for the county to be heard. The county has filed 9 separate exceptions, and rather than addressing them in the same sequence that they were presented in the materials that you've reviewed, we have reached an arrangement that has us addressing them in 3 groupings that make a little bit of sense as far as, well, hopefully more than a little bit of sense. Hopefully they will make sense to you as far as moving through and analytically considering them in those groups where they are interrelated. They're all a bit interrelated, so we may go back and forth a little bit, but I think that the grouping structure will be helpful. What the council determined as far as a way of going through this hearing process is that it will be important for each of the 3 parties to be heard. So we'll begin, and for each grouping, we'll have sort of an opportunity first for the county to present its exceptions, then for I'm trying to remember which order we have it in, the applicant, and then the Department of Energy to provide any responses that they have. The first grouping is just 1 exception. The second 2 groupings involve a collection of exceptions. In the interest of making sure that the county has a full opportunity to say everything that it wishes to say, we've increased the amount of time available according to the number of exceptions being considered, using about 3 minutes per exception per party as the kind of guideline. Within that, the county and the other parties can use their allotted time for each grouping to either march one by one through each exception or to handle it in a more global way. That's what's been offered as far as a format for this exceptions process. I did want to invite anyone who has any adjustments to that to chime in, or any questions about it.
Ms. Miles, Tim McMahon for the record, Chair Drew, council members. Given that through the cycle of 9 briefs in this matter and some fairly extensive legal arguments surrounding all this, and given the fact that the applicant and the Department of Justice really are fundamentally on the same page in terms of the legal issues, I'm going to recommend, and I've checked with counsel on this, that I'm going to present at the very end of the process for about 5 minutes to economize considerably in time, I think, and to avoid the redundancy that's inherent in both Mr. Rowe and I going back and forth on much of the same material. So with your confirmation, that's the way, at least the applicant intends to handle this. Thank you.
Okay, I think we can move. Oh, sorry. Oh, yes.
Thank you, Lady Wellington, representing Umatilla County. Thank you very much for allowing me to be here. Really appreciate it. And
I'm over here and I can hardly hear you, so I'm going to be worried about the folks in the back. If you could please speak a little louder.
does this room, the WebEx. Okay. All right.
Thank you.
Got it. Thank you. Wendy Kellington. I'm representing Umatilla County here. Thank you very much for allowing us to present today. Just sort of piggybacking on what Mr. McMahon said. I'm wondering if the county might at the end have just a few minutes to do a responsive wrap up, if that's something. So just kind of, because there's a lot of this that feels a little disjointed and that feels like, so if you would indulge us that, we'd certainly appreciate that.
Well, we have no problem with that. Thank you.
Thank you.
And I think it would be, if the department wishes to do the same thing at that time, it would be free to. You can make that determination at a later time.
Or may not.
Okay, so with that, I think we can turn to what we've characterized as the first grouping. We go to the next slide. Perfect. That is the one. So this exception presented by the county is in the materials provided by the county under subsection B4. I think I'll read it so that we all can, make sure we track exactly the way the county presented this. The exception is as follows. Relatedly, the ALJ in their order on petitions for party status and issues for contested case order, which is in parentheses here referred to as the issues order, has already decided that whether criterion 3 is an applicable substantive criterion is not within the council's authority. There is a specific 7-day period of time for filing objections to the issues order, and none were filed, citing OAR 345, 15, 16 sub 6. That means, as a matter of law, the proposed contested case order misconstrues applicable law by deciding that criterion 3 is not an applicable substantive criterion. We've moved this into the initial grouping because it is sort of a quasi-procedural issue and has sort of a threshold issue that the county is raising about whether the issue was sort of already decided by the issues order. And so with that,
Thank you for the record, Todd Cornett. I'm going to keep track of time so we don't have a clock up on the screen. So in this one, there's 3 minutes. Obviously, it changes per when the party begins speaking. I will begin the clock. At 1 minute, I'll raise my finger to let you know that you have 1 minute left. And then at the conclusion, I will let you know that you're done.
Okay.
you may.
Wendy Kellington, representing you. Again, thank you very much for allowing us to be here to talk to you, to frame this issue. I want to be sure that you understand that this issue is extremely important to Umatilla County, so important that today we have all members of the governing body here who represent the entirety of all of the citizens of Umatilla County, as well as the county council, the planning director, and an assistant planner, and all that Umatilla County is asking you is to please faithfully apply the law, because we believe that if you do that, that you will not adopt the PCCO and will find for the county. It has already been decided that the issue of whether criterion 3 is an applicable substantive criteria is not a determination that is within the jurisdiction of EFSC to decide. And I have a PowerPoint that hopefully is in front of you that you can look at and follow along. The ALJ has already decided, and I quote, an evaluation of whether the land use ordinances passed by the county are required by statewide planning goals is not within the council's jurisdiction. It couldn't be clearer. That ruling is final under an administrative rule that says that the ALJ's determination is final unless someone appeals within 7 days. Nobody appealed within 7 days. And that means, as a matter of law, that determination that an evaluation of whether the land use ordinances passed by the county are required by the statewide planning goals is simply not within the council's jurisdiction. Final means final. The second ALJ, who wrote the PLC or PCCO, improperly ignored that ruling and collaterally attacked the first ALJ's ruling. She didn't even address this issue in her order. She proceeded to do exactly what the first ALJ decided was beyond the scope of the proceeding, to evaluate whether the identification of the applicable substantive criteria was within the planning goals. Odo faults the county for not raising this issue in its request for contested case, but it didn't have a crystal ball to be able to know what the first hearings officer would decide with regard to the scope of the proceedings. Thank you.
Patrick Rowe, Department of Justice for the Department of Energy. The council should reject this exception for two reasons. First, the issues order establishes what issues are to be addressed in the contested case. It doesn't rule on the issues. Second, the county misinterprets the rule that addresses appeals of an issue order. It reads that rule far too broadly. So I'm going to repeat that. Two reasons why you should reject this exception. The issues order establishes what issues will be addressed in the case. It doesn't rule on them. The county far too broadly reads the rule that governs appeals of issues order. The final document that the ALJ issued in the contested case was the rulings on motions for summary determination and proposed contested case order. In that order, in the PCCO, the ALJ ruled that the county's setback is not required by statewide planning goals. Since it's not required by statewide goals, the setback is not one of the applicable substantive criteria that council must require an applicant to comply with. In this exception, the county argues that the ALJ was precluded from making that ruling because of an offhand remark that the first ALJ had made in the issues order. The county is referring to the November 2nd order on petitions for party status and issues for a contested case. The purpose of those orders are procedural, not substantive. Those orders establish whether people seeking to participate in the case meet the requirements for participation. Did they sufficiently raise their issue on the record of the DPO? Those orders establish whether petitioners participate in the contested case as a limited or a full party, and they establish the phrasing or the framing of the issues for the contested case. They don't serve as rulings on the issues. The main issue in this case is whether or not this the criterion 3, the setback, is required by the goals. The hearing officer made an offhand remark. The issue before was not before her. She wasn't being asked to address whether council has jurisdiction. That was not an issue that the county raised. No one talked about that before that order was issued. She made an offhand remark. When you make an offhand remark, that isn't necessary for you to resolve what's before you. When a judge does that, that's called dictum, and it's not binding in the case. That's what happened here. That's clearly what the second ALJ felt, because she didn't act as if the contested case can't proceed. She proceeded, analyzed the substantive issues, ruled against the county. As far as the appeals, quickly, that rule says this: the hearing officer's determination on a request to participate as a party or a limited party is final unless it's appealed within 7 days. That's what has to be appealed within 7 days. A ruling on a request to participate as a party or limited party. That's not what's at issue here. That's all. That's the extent of what needs to be appealed within 7 days. So, thank you.
Nancy, can you put the next slide back up, or is that? Yeah, it should be, yeah, the next one called, council straw poll.
Excuse me, before you continue, Patrick, just because, will you please tell me the word that you used when you said she made the offhand remark?
Victim.
Thank you.
Yes, and with the applicant not addressing this issue at this time, it really is an opportunity now for the council to consider whether you have questions, first of all, about what you've heard, and whether you know, based on what you've heard, you feel that it would be appropriate to make any changes, or you know, the option indicated there, number 2, any specific changes with regard to this exception, or if you're comfortable with the conclusions reached by the ALJ and the proposed contested case order, which agrees with the proposed order recommended by the Department of Energy.
Thank you. If the ALJ hadn't made the remark, is there any difference how the case would have proceeded? It seems to me that would have proceeded exactly the same. Is that correct?
Counselor Condon, thank you for that comment. Wendy Kellington for Umatilla County. The determination was a jurisdictional determination, which the rules require. And so we expected that a determination on jurisdiction would be made. So it's not dicta. And so the case would have gone very differently had the ALJ determined that the scope of EFSC's jurisdiction included making that determination. As you know, our motions for summary, the county's motions for summary determination explained in some detail that the council doesn't have jurisdiction to review a determination made by the special advisory group regarding the identification of the applicable substantive criteria, that only the Oregon Supreme Court has that authority. That part of the case, had the ALJ ruled otherwise, not been there, it just would have been different.
Council members, Tim McMahon for the record. Procedural question. Are we going to have back and forth argument after the presentation of each exception? I don't think that's within the anticipated process that was laid out in the agenda for these proceedings, and it's going to take a very long time if we're going to argue back and forth on everything, single exception. So I do object to that happening here.
Yeah, I think at this point, it certainly is an opportunity for the council to ask questions. And if I, as counsel to the council, can provide any clarification regarding, you know, what you're considering, that is what I'm here for. I would ask in the future that we pause before anyone else jumps in at that point. So with regard to this exception, does any member of the council have a question that you'd like? We'll kind of consider the order globally at the end of this process. And so we're not asking you to, in the straw poll, you know, make that final determination about whether you believe any specific changes are necessary throughout the whole thing. But just on this exception, is there anything that anyone has concerns about, or should we move on? Okay. Okay, the straw poll, if you could facilitate that, that would be helpful, Secretary Cornett.
Yeah, so just to clarify again, sort of three options. One, you agree with the proposed contested case order, findings of fact, conclusions of law with regards to this one issue. Agree with the proposed contested case order with potential changes, or do not agree with the contested case order in this matter. So just to get your sense moving forward, as was indicated, we can, broadly revisit the proposed contested case order at the end, but I think this will get us sort of piecemeal. That way it's, in another couple of hours, it'll be hard to go back and sort of sift through all of the details of each of these. So I think in this incremental way of doing the straw poll helps us sort of establish where you're at these particular exceptions. So any thoughts on what you're?
I agree with what you just said as far as the procedure, and from the standpoint for straw poll, do you want us to verbally do that? Do it?
Yeah, I mean, I can read it, but I want to know where you're going so I can read the correct one.
Oh, I would be in support of agreeing with the findings of fact and so forth.
For the record, Councillor Byer, I would agree with the findings of fact and conclusions of law in the proposed contested case order.
That's Cindy Condon, and I would agree as well.
This is Jordan Truitt. I agree.
Marcy Grail, I agree.
This may sound like the most unusual response, but I agree, but I want to keep my options open based on further testimony.
Sure. Yeah, so I think verbally I heard from everybody. Essentially, your straw poll is with number one. I will make note of that, and I don't need to call roll.
Thank you for that. With that, we can move to the next slide. This grouping relates to Umatilla County's exceptions B sub 2 and B sub 3. I'm going to read each of them. Criterion 3 is an applicable substantive criterion under ORS 469504 and OAR 345, 2230 sub 3. And the proposed contested case order erroneously asserts that it is not an applicable substantive criterion because it is not required by the statewide planning goals. That is the first exception in this grouping that the county presents. The second, ODO and EFSC do not have jurisdiction to review or reverse the special advisory group's identification of criterion 3 as an applicable substantive criterion. These are grouped together because, as you can see, they both relate to the issue of criterion 3 and it's whether it's an applicable substantive criterion. With that, we can give the county an opportunity to address these two exceptions.
Ellington, again, representing Umatilla County, and thank you. This exception has, as grouped by the department, has two pieces. Who gets to decide what the applicable substantive criteria are, and then who reviews that determination. And then there's a third part, and then regardless of who reviews, does goal 2 require the county to adopt ordinances, including criterion 3? And our answer to that is yes. With regard to the first, again, your PowerPoint that we've provided, the statute says the elected governing body of Umatilla County is a special advisory group. It says that when they go to the trouble of identifying applicable substantive criteria, that the EFSC is required to apply it. And the first ALJ, of course, as we just went through, got it right, that said, under that scheme, under the statutory scheme, EFSC doesn't have authority to review that determination. Rather, the sole authority to make the determination at this level is with the governing body. And of course, here, the second scenario that applies says that once the governing body's done that, they've identified a standard such as criterion 3, it shall be applied. So there's this particular statute, ORS 469-5048, that says that the county's identification of the applicable substantive criteria, and I quote, shall be subject to judicial review only as provided by 469-403. And that's the Oregon Supreme Court. But instead, the PCCO wrongly purports to review the governing body's determination. Accordingly, under ORS 469-5048, that was improper. With regard to the merits, the ALJ, the PLCC, correctly says that the 2-mile setback established by the governing body is not an applicable substantive criteria. But what is the description of an applicable substantive criteria? The administrative rule says it's criteria from the affected local government's acknowledged comprehensive plan, that's the county, and land use ordinances that are required by the statewide planning goals, and that are in effect on the date the applicant submits the application. State statutes are the same. The 2-mile setback meets that description. The 2-mile setback was in effect when the application was filed, and it is required by at least Goal 2, whose purpose is to establish a land use planning process and policy framework for the basis of all decisions affecting land use. Goal 2 expressly requires counties to hold public hearings, evaluate information from the public in public hearings, and make ultimate policy choices based upon their citizens' social, economic, energy, and environmental needs, and then to reflect those local determinations in plans that, and I quote, shall be the basis for specific implementation measures, i.e. criterion 3. Criterion 3, the 2-mile setback, does exactly what Goal 2 requires the county to do. It cannot be said otherwise. Based upon written and oral testimony, the governing body established the 2-mile setback from rural residences and turbines. There is no serious claim, really, that criterion 3 doesn't do exactly what Goal 2 requires. That means the county's adoption of the 2-mile setback is required by Goal 2. Goal 2 further requires that state actions related to land use shall be consistent with the land use rules of cities and counties. So even if EFSC were to apply the goals directly, the result would be the same. EFSC has to comply with Goal 2. There's no sort of magic thing that says, well, you can ignore Goal 2 and you have to, apply everything else. No, all of the goals apply. Goal 2 required the county to adopt exactly that. And if you establish a precedent that says, well, unless counties have an absolute duplicate of the local standard that is adopted that a particular commercial wind developer doesn't want to comply with, or any energy developer doesn't want to comply with, you're basically saying there's no local land use standards that are ever going to apply, because the whole point of the system is to set broad policy objectives, and we've cited a bunch of Supreme Court cases that talk about this, set broad policy objectives that local government are required to synthesize and apply by adopting, after public hearings, hearing from the public, based on substantial evidence in the record, adopt local rules that do what the county feels is best as a matter of land use for the county. And that is what Goal 2 fundamentally requires. And you don't want to set a precedent that says Goal 2 is irrelevant. It doesn't really require anything, because that's not what it's ever been held to say. That isn't what it says. It says, county, go out and do what you did here. Adopt local rules, including rules on energy, and the county did exactly what it was required to do. It's acknowledged as being in compliance with the goals, which isn't the end of it. They were required to do what they did. And now Odo is saying, and the PCCO says, well, you can ignore that. Because there's no specific goal that says you have to have a 2-mile setback from wind turbines. Well, of course there isn't. Of course there isn't. Thank you.
For the Department of Energy, the ALJ correctly held that the county's setback ordinance criterion 3 is not an applicable substantive criterion. You have before you a handout that I provided. The cover page looks like this. The second page is the rule. You've heard this definition. I've highlighted it. It's 345-2230 sub 3. Want to make sure you're there, Councilor Howe. This is the first page. Go to the second page. Look at our rule. This is the key to the whole case. What's an applicable substantive criterion? Applicable, that's what you need to apply. The county needs to recommend applicable substantive criterion. If it meets the definition, then you apply it. In the definition, it says that the applicable substantive criteria they recommend have to be required by statewide planning goals. This setback is not required by any goal. If it was required by a goal, every county would have such a setback. To the department's knowledge, Umatilla County is the only county in Oregon that has a setback such as the one that they're suggesting you must apply. The department sees that setback as a not in my backyard type ordinance, a NIMBY ordinance. Umatilla County doesn't like it. When they first adopted it, one of the reasons why they said they were adopting it was to protect property values. Protecting property values, while it might be a noble goal, is not a goal that is required by the statewide land use planning goals. With regard to the goal 2 argument, it requires cities and counties to adopt comprehensive plans and to enact land use regulations to implement those plans. Nothing in goal 2 requires a local government to enact regulations establishing setbacks for wind turbines or to protect citizens' property values. The county's argument that goal 2 requires you to apply the setback directly conflicts with statutes governing the EFSC process. And here I'm going to refer to you to the same handout, 469504, the first page. If you look at subsection 6, which is actually, the second page, and I've highlighted the relevant language. Subsection 6, actually, I didn't highlight it, but it's in subsection 6. Subsection 6 says the council is not subject to ORS 197.180. What does 197.180 says? That statute requires that state agencies ensure that their actions are consistent with local comprehensive plans and regulations. The legislature says, EFSC, you don't have to make sure what you do is consistent with local comprehensive plans. It says the opposite. If you look at ORS 4695047,
popping up everywhere.
same statute, one rule, one provision down, it says, I want to make sure I'm there. Each affected local government, in this case the county, shall amend its comp plan and land use regulations as necessary to reflect the decision of the council pertaining to a site certificate or amended site certificate. It's right in statute. So what does that mean? It means if you decide county is recommended and county has this ordinance that has a setback, but if you decide the setback doesn't apply, they need to amend their ordinance. So what their ordinance ought to say is, we have this 2-mile setback, but if you go before EFSC, it doesn't apply in the EFSC process. Right in the statute, they need to amend to make consistent with your decisions, not vice versa. So contrary to the county's argument, it is the county that must amend its comp plan and regulations to be consistent with EFSC's decision. So we're talking here just about the first of in this grouping. The department respectfully suggests that council reject that exception and agree with the proposed contested case order holding that the county setback is not an applicable substantive criterion because it is not required by the statewide goals. I will also note that this was considered by you when reviewing the draft proposed order, and your former colleague, Chair Jenkins, made that same statement on the record that he agreed with staff that the setback was not required by the statewide goals. I need to go quickly on the next in this grouping. This is the exception that says ODO and EFSC do not have jurisdiction to review or reverse the Special Advisory Group's identification of criterion 3. Our response is yes, you have jurisdiction to determine if a recommended criterion is recommended by the statewide goals. Proposed contested case order correctly held that to the extent the local government recommends criteria not required by the goals, council has no obligation to apply that criteria. That is what the ALJ ruled. There has been an argument, and Ms. Kellington brought this up, that under ORS 469.5048, again, it's in this handout, that divests the council of the authority to conduct this review, that only the Supreme Court has that ability. That is not correct. That statute does not prohibit you from reviewing it. It establishes that judicial review goes to the Supreme Court. Normally, land use decisions go to LUBA, the Land Use Board of Appeals, and then the Court of Appeals. All this is saying, consistent with appeals of your final decision, consistent with appeals of rules that you draft, it doesn't go, those appeals don't go to LUBA, they don't go to the Court of Appeals, they go directly to the Supreme Court. That's all. It's not saying that you don't have the right to do it. It's saying that when a court reviews